overpaid child support, a recalculation that slashes income nearly in half. And now, one parent is demanding thousands back. This isn't just about numbers, this is about accountability. Did someone knowingly accept inflated support? Or was this a paperwork nightmare spiraling out of control? Today's courtroom battle dives into recalculations, alleged overpayments, and whether fairness means paying it back, even years later. And just when you think it's settled, a second motion throws accusations of fraud into the mix. Who's right? Who dropped the ball? And what happens when the court says you should have brought that evidence sooner? Let's break this down.
The child support calculation that was giving her so much child support had her income at $15,000 per year. When we recalculated child support, the child support was at $50,000 per year for Ms. Chilton's income. And that was what it was recalculated on. Client's kind of stuck where he's overpaid child support for years, essentially.
I was not trying to be deceiving in any way.
Arthur Robertson versus Brandon Chilton. Today is
The court will note the appearance of Ms. Greenlee-Clore on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for repayment of overpayment of child support. I've read the pleadings, Ms. Greenlee-Clore. Is there anything else you have to add?
The only other thing I have to add, Your Honor, is looking back at the documents, the calculation, first of all, Ms. Chilton is an intelligent woman. She knows how child support works. The child support calculation that was giving her so much child support had her income at $15,000 per year. When we recalculated child support, the child support was at $50,000 per year for Ms. Chilton's income. And that was what it was recalculated on. There's no way that Ms. Chilton knew, or there's no way that she did not know that child support shouldn't have been at that level that it was at. And I don't know that's not up for debate today because it's already been modified. But at this point, my client's kind of stuck where he's overpaid child support for years, essentially, to Ms. Chilton.
Here's where this gets serious. The plaintiff's argument is simple but powerful. The income used in the calculation was dramatically off. One version shows $115,000. Another recalculation shows $50,000. That's not a small discrepancy. That's massive. And in child support, income drives everything. The attorney is basically saying there's no way she didn't know this was wrong. That's a bold claim. But remember, today isn't about whether the original amount was incorrect. That's already been modified. The real question now is, if someone overpaid for years, does equity demand repayment? Or is that just the cost of a system correction?
But he has no way to get any of that child support back. And as our motion indicated, he tried to pursue this. It didn't come back. And I think what we need to do is we probably need an order from this court with how this is supposed to get paid so that if he does need to, he can pursue collection action.
Okay.
Thank you, Your Honor.
Thank you. Ms. Chilton, what's your response?
Good morning. At the time when this was calculated, as I presented to the court, I was only working part-time, and the order was based on that part-time work ending in that summer of June or whenever that school year ended. And again, as I put in my answer, that I was not going to be working over the summer because I was going to school. And then once I went back to work in August, which, I did have a full-time job at that time, that is when I submitted the documentation to the child support court that I was in fact earning more money. So I did submit documentation. I didn't understate any income. We had to submit documentation to the court at that time to prove my income at that time. And so I don't feel like it is at my fault that that the child support stayed in that way. Once I submitted documentation to the court of my full-time employment, it had not changed, so I took it back to the court. I submitted it twice, as you will see in the documentation and supporting evidence that I did submit this documentation to the court twice. So I submitted, I did everything that I knew to do. I was not trying to be deceiving in any way. I submitted the information that I had that I knew that I needed to submit. And that income was based on him working more at that time. And then he went on to a different job that caused him to work make less. So the recalculation, I'm not sure where the $50,000 is coming from, but again, I was not working prior to that due to COVID. And then we started working.
Now we're hearing the defense. She's saying she submitted documentation twice. She claims she wasn't hiding income and that she updated the court once her employment changed. That's critical because child support relies on transparency from both sides. If she truly provided updated income information and the court didn't adjust it immediately, that weakens the idea of deception. But here's the twist. The judge isn't revisiting blame. The modification already happened. This hearing is strictly about money that was paid under an incorrect number. So ask yourself, does intent matter here, or does math override motive in family court?
We started working part-time, and the child care that I was asking to be paid for at that time was not being paid for. So that's when the child support came up, because he wasn't meeting his obligation that we had agreed upon.
Okay. Well, in this particular case, I'm not going to address the issue of the amount of support because that was changed and it's already been resolved. I understand the arguments, but it would be inequitable to charge the plaintiff an amount, and again, that would, in essence, have him paying over $7,000 that he should not have had to have paid had it been calculated at that correct amount at that particular time. So the court is going to grant the
And there it is. The judge grants repayment. Notice the reasoning. It would be inequitable to let someone keep over $7,000 that shouldn't have been paid under the corrected calculation. That word inequitable is everything. Family courts operate heavily on fairness. The judge isn't punishing anyone. He's balancing the scales. What's also interesting is how he structures it. Repayment over the same term it was collected. That softens the blow. No lump sum shock, just symmetry. Paid over 12 months, repaid over 12 months. That's judicial practicality at work.
Motion for the repayment. Screenly Core, what I'm going to do is order that the amount of $6,891 would be repaid over the same term that it was collected. So if it was collected over, I think you said over 12 months, then that would be repaid over 12 months. If it was longer, I just don't know based upon the pleadings that are filed over what time that was collected. So I'll simply order that you can figure out when it was collected and then have the repayment over the same term.
Your Honor, so just to clarify, dating back to the court backdated support to March of 2022. Are you saying March of 2022 to today would be the repayment period?
No, I'm saying the time that he paid the overpayment, that the repayment would be over the same term. So if it was 12 months, if it was 18 months, I don't know from the time that he began paying that $764 and the time that it changed to the 34. So it would just be repaid over the term that it was paid.
Okay, and equal monthly installments, Your Honor?
Yes.
And then no, we also made a request for attorney fees in this case. Is that
And notice what the judge does here. No attorney fees. That's important. Even though repayment is granted, the court acknowledges there were enough issues and problems floating around. That tells us this wasn't a clean-cut case of bad faith. It was messy, complicated, possibly procedural confusion. Courts are reluctant to escalate conflict with fee awards unless someone clearly acted improperly. So at this point, it feels like a reset. Repayment ordered, but no additional penalties. Case closed, right? Not quite.
I'm not going to award attorney fees in this case. It sounds like there were enough issues and problems in the case to go along. I don't hold anybody responsible for that.
okay? Thank you, Your Honor.
Okay, thank you. You're free to go. You can submit that under 7 days.
Thank you.
There was a fraud committed on the court. Plaintiff had filed a motion to set aside referee recommendation, claiming that the defendant was making more than that she had told the court. Sir, at the hearing on October 20, 2023, you could have presented any evidence you had concerning her income. Why didn't you do that?
Well, I actually sent out I sent out a subpoena for it, but I might have sent it out too late. I have a date without my date of delivery was on when I got this back was on the 18th. I think that was what, two or 4 days before the actual hearing. So I sent out for the evidence, but I got it sent out a little too late, I believe. Not enough time to get it back.
Well, a couple things you could have done at the hearing. You could have asked the referee for an adjournment to be able to get that information, rather than at this point, you don't, my understanding, you don't have any information now at this point that would contradict her testimony. Is that correct?
Correct, because they still haven't sent it to me yet. I'm not.
Okay.
I sent out the like I said, I sent out the subpoena for it, but I never got the information.
Okay. Well, what the court's going to do is the court can't just speculate as to what somebody's testimony may have been. What I'm going to do, no.
The second motion is where things unravel. Now we're hearing allegations of fraud, but here's the problem: no evidence. The judge makes something crystal clear. Courts cannot speculate. If you think someone lied, you must bring proof. Subpoenas sent too late? That's a procedural mistake, not fraud. The judge even explains what could have been done. Request an adjournment, secure documentation properly. Family court rewards preparation. Without hard evidence contradicting testimony, the judge's hands are tied, and that's a harsh but consistent reality of litigation.
You don't need to, ma'am. What I'm going to do is I'm going to deny your motion, sir. If in fact you get information that in fact her testimony was incorrect, you always have a right to file a motion claiming that there was a fraud committed on the court, and the court could take that up. Likewise, you also mentioned that you are now paying for medical insurance that you hadn't before. If that's correct, send the information to Mr. Todd. And maybe at that point, he would agree to modify that, taking into account or giving you a credit for that medical premium. But at this point, you don't have anything which would cause the court to, again, modify and change the referee's order. So I'm going to deny it at this particular time. But that would be the way you want to proceed if you get other information, sir.
Okay, so I have another question. As far as he backdated it to July.
He would date it to the date that the notice of, again, the modification would have occurred. That's correct.
Yeah, so that put me over $1,600 in arrears
I
already.
understand, but what happens is during that interim period of time, you weren't paying the correct amount. So that's always a risk, because we don't know if it's going to go up, if it's going to go down, et cetera. But again, the referee did exactly what he was supposed to do, is he would have modified it effective the date of the motion to modify. So he did everything correct. So again, the court's going to deny the motion, and that will conclude this matter at 10:36 a.m. You're free to go. Have a good day.
Your Honor, did you want me to prepare an order, or was the court going
No,
to-
the court will have an order that we'll send out.
Okay, thank you.
So here's the full picture. First, the court orders repayment of overpaid child support, structured fairly over the same time frame it was collected. No attorney fees, no blame assignment, just financial correction. Then, in a separate motion, allegations of fraud fall flat due to lack of evidence. The judge reinforces a key legal principle: bring proof or the court cannot act. Procedural timing matters, documentation matters, preparation matters. In family court, math and evidence rule the day. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.